Both Fred and I have had some litigation experience, and unfortunately, in elder law, even with good planning, sometimes you end up in court.
The typical case is a gentleman passes away and leaves substantially all of his assets to a person or persons other than his natural beneficiaries. And by natural beneficiaries, we mean typically the children of the decedent. Many times people, particularly elder people, come under the influence of persons and are induced to leave portions of their estate to those persons. And in many cases, the elderly person did not fully realize what he or she was doing. And in a typical case, someone will come into the office and say, "My goodness, this is my dad's will. I hardly know this person. How could he possibly have left so much to so-and-so? Can you do anything about this?" And at that point, Babette takes over.
And on the other hand, there are times when an elderly person knows exactly what they're doing, and they intentionally disinherit an heir. And sometimes we get very involved in preparing that case for litigation, even while the testator is alive and writing the will, because we anticipate that it might be contested at a later date. And so we develop the case right then and there on the spot. Unfortunately, that's not always the case, but we believe in a person's right to leave their estate to who they choose. And that is one of the liberties we have in the United States and in the Florida Constitution. And in protecting the elderly, we're protecting their freedom of choice. And not every estate is the same.
In those types of situations, we will frequently videotape the person who is making the will. In other words, we will videotape the signing of the will. We will ask that person who you are, do you understand what you're doing, who are your beneficiaries, what is the nature and extent of your financial assets, and how come you're not leaving so much to so-and-so, and how come you're making a bequest to so-and-so. In other words, we have it all on tape. And when the person dies, and if there is litigation, the judge and the jury and everyone else can see the person who prepared the will while they were alive, can make a determination of whether they feel they were competent when they signed, and they also hear right out of the person's own mouth why they are or are not doing a particular thing with regard to the disposition of their assets. And we have found that that videotaping can be very persuasive in a court of law.